Welcome back to another chapter on the North Carolina Real Estate Exam Prep. This is Chapter 10. It's been a little while since I've mentioned this, but I just want to remind you that this class isn't necessarily meant to replace going to your actual class or reading the book or anything like that. It's just meant to be helpful and supplemental to that stuff. I see it as a resource to watch maybe before going to class and then again maybe before your test. Regardless, thank you so much for watching. This channel has grown a lot faster than my other channel, and so I'm just really excited to see where this goes in this next year, as my previous channel has been flying through the roof lately. And the last note, I've had a couple of comments on some errors I've made in some previous videos. And so moving forward, I'm going to continue pinning a comment at the very top of my comment section down below these videos that will highlight or show any of the corrections I need for the video, since I can't edit any of these after I upload them to YouTube. Alright, so you ready to get into it? Chapter 10 is all about sales contracts and related procedures. As mentioned previously, realtors, brokers, we do not conduct or practice law. So many of the contracts and forms that you'll be using will be provided to you by your firm. These forms have been vetted by lawyer after lawyer and have been used by realtor after realtor, so you're most likely going to be pretty safe. The North Carolina Association of Realtors doesn't actually create any of the forms. Again, those forms come from your firm. But the North Carolina Association of Realtors does create rules and procedures that must be within your contracts. So when it comes to purchase contracts, I just want you to note that commission is never stated in those contracts. Those are left for the listing agreement and the purchasing agreement. Also, these contracts never disclaim any liability, so you can never really be cleared of any wrongdoings. And that's why it's so important for you to make sure you do your due diligence, make sure you do disclose any of your material facts, because you can still be liable. All documents must be delivered immediately, but never later than 3 days. So a question I saw in the test, and I would call it a trick question, asked, how long do you have to deliver your documents? And one of the answers was 3 days. And so a lot of people would look through there and see 3 days and click it because it is a correct answer. But there was another answer on there that said immediately, but never more than 3 days. So that was the answer you should have selected, or I should have selected. So no question on a test should ever have two correct answers, but in cases like this, you just have to be careful. As briefly mentioned before, a broker should never conduct law or make or create any of the forms or contracts themselves. You are allowed to pre-fill, or you are allowed to fill out any pre-made documents and fill in any blanks and things like that. Let's talk about offer to purchase documents. So an offer can be accepted, rejected, or countered. You may withdraw your offer at any point prior to the offer being accepted by the other party, without any penalty, without paying any earnest money or due diligence or anything like that. But once that offer is accepted and communicated back to you, you are now under contract. In some offers, there are contingencies, which are conditions that must be met in order for the contract to be valid. Some contingency examples are selling your house before buying another house. So if I put an offer on a house, and I'm currently living in this house, me buying that new house would be contingent on the sale of this property. So if I were to not be able to sell this property, then this wouldn't fall through. I would not be able to buy that other house. Some other contingency examples are things like appraisals and financing, and there's some other ones. This is the perfect time to get to the due diligence period. This is a window of time that you have to check for any issues and resolve them prior to closing. This is your time to get your inspections done, your surveys, appraisals, look at zoning, talk to HOAs, and so many other things. A buyer can walk away at any point during this due diligence period, but they would have to give up that due diligence, the negotiated due diligence amount, which is usually like a $250 to a $500 fee, depending on what you negotiated. If a buyer were to continue with the purchase of this property after the due diligence period, the due diligence fee amount would actually go towards the sale price of the property, along with the earnest money. So what's earnest money? It's basically the negotiated amount that a buyer provides to a seller that basically pays them to take the house off the market temporarily, and it's usually about a $1,000 fee. You can see it to $2,000 sometimes and even higher. This also ends up going towards the sales price of the home if the buyer continues and closes on the contract. Due diligence is a check that goes directly to the seller, like you literally write it out to their name, and the earnest money is a check that goes to a trust account or your attorney's. The due diligence you really never get back unless there's some kind of breach in contract, while the earnest money you will get back if you back out during the due diligence period. But once that due diligence period passes, then if you back out, you now give up that earnest money as well. So time is of the essence, which means that time is very important. When it comes to the due diligence period, you can negotiate on a date. On that date at 5 p.m. is when the due diligence period ends. If you go after that point and you decide to back out of this deal, you now give up that earnest money, as I just previously said. Before 5 p.m., the seller only gets the due diligence amount. After 5 p.m., the seller gets both due diligence and earnest money. What this also means is that the buyer can back out of the deal the day before closing and would only lose the due diligence amount and the earnest money amount and maybe any other amounts for inspections and surveys and things like that. But the seller would then have lost all that time and have only received whatever money they negotiated the due diligence and earnest money amount for. Now we'll cover a few other contract things. The settlement date is the date that everyone goes together and signs all the forms. The closing date is the date that the attorney goes to the courthouse and records all of your documents. This can also happen a day after settlement date, which would be really annoying because then you wouldn't get the keys on the settlement date, you would get them the next day. Or if it's a Friday, you won't get them till Monday. Amendments are changes to a contract. Things like changing the sales price, changing the close date, changing the earnest money amount, things like that. Addendums add things to a contract. Like maybe you want to purchase all their fixtures or furniture around their house or something like that. It's when you add things to a contract. If there are multiple offers on a property, you can't reveal them to all the buyers or all the offerers unless you have permission from all the offerers. All buyers also must be treated equally. So you can't go back to just one offer and say, hey, if you can offer just a little bit over that $200,000 offer, I think we'll have a deal, and not tell that to any of the other offerers that have come through. You'd have to tell all of the potential buyers if you were to tell one buyer. Communication is next. And this is actually the biggest flaw for most realtors. Just answer your phone, guys. Come on. We'll stick to the rules though, and I won't get into how to be an actual good realtor. But just answer your phone. You must communicate all offers promptly. It doesn't matter if it's an extremely lowball or ridiculous offer, you must still negotiate that or communicate that back to your client. When you accept an offer, you must communicate that back to the other side, and you can do that in person, orally, over the phone, through text, email, through fax, maybe even a carrier pigeon, something like that. If an offer is accepted and signed, it doesn't matter until it is communicated back to the offerer. You can't just sign the offer and be under contract. You have to tell the other side. Also, as soon as you hit that send button, the offer has been accepted and communicated back. This is called the mailbox rule. The other person doesn't necessarily have to receive it yet. As long as you hit that send button or you put that offer acceptance in the mailbox, something like that, it is now considered a valid offer acceptance. Also, it does not matter if you communicate that acceptance to the agent or to the buyer. Communication with the agent is communication with the principal. There's another type of contract to purchase a home, basically on layaway, and it's called installment land contracts. This is basically where you make monthly payments on a property, but you don't actually get possession or rights to that property until all of your payments are completely paid off. If the buyer were to fail to pay at some point, then the homeowner would keep all of the old payments, all of the previously made payments, and keep the house. And the buyer only has 30 days to cure any of those defaults. Then you have the options to purchase, which if you refer back to Dream Oils, it's what the O means. Options to purchase is when a homeowner has to sell if the buyer decides to buy. This gives the buyer the right to buy at some point. Think about a lease-to-own situation. A renter is renting out a house with the option to end up buying that house eventually once all their payments are made, or they can go ahead, if they have the funds, to go ahead and buy off that house right then and there. But they can also decide to never buy, and they'd be okay. The actual homeowner has to sell though if that renter does want to buy. This is called a unilateral contract, which we discussed a little bit previously in a different chapter. Alright, I feel like that one went by really quick, but now it's time for the review. What'd you think? Okay, where do forms and legal documents come from? They come from our firm. not the North Carolina Association of Realtors. The North Carolina Association of Realtors creates rules, but not forms. When it comes to purchase contracts, our agent commissions are never referenced. Those are left to the listing agreements and purchasing agreements. And liability can never be waived per se. We are always somewhat liable. Almost all documents we talk about in this entire series must be delivered or received within 3 days, and this is just a standard again across most documents. Remember, you should move all documents immediately, but never later than 3 days. A sales contract must always be in writing. Remember, it's part of the Dream Oils here, which is a Statute of Frauds Act, where these documents must all be in writing. A contingency defines a condition that must be met for a contract to become binding. During due diligence, you need to make sure that your clients get their surveys, appraisals, inspections, all these things done. So you can back out any reason during this period, but once you pass that period, you then owe the due diligence and earnest money amount. If you back out during this due diligence period, you only miss out on the negotiated due diligence fee amount. You get to keep your earnest money. Amendments are changes to a contract, while addendums are additions to a contract. See what I did there? I added the add there. Yeah. If you are a listing agent, you must disclose all offers that you got on your house, even if they're crazy lowball offers. When an offer is given from a potential buyer to a seller, that acceptance of that offer must be communicated back to the buyer. Otherwise, you're not under contract yet. The mailbox rule states that as soon as that acceptance is sent, you are now under contract regardless of whether the other side, the buying side, has received the offer or the acceptance or not. Installment land contracts are when you buy a home on layaway. Options to purchase are cases like lease to owns. A renter can choose to buy a house if they wanted to, but they don't have to buy the house. But the homeowner would have to sell the house to that renter if the renter did want to buy it. Remember, this is a unilateral contract. And that's it. If you would like for me to make a midterm review at some point, just let me know by hitting that thumbs up button down below. Again, I don't really know what to expect from this channel, but if I get a few dozen likes, I'll get the hint and I'll eventually create one. So I appreciate each and every one of you watching right now. My other channel has just been blowing up lately with about 100 subscribers every single day. And I eventually want to make this my primary channel. And this one is already growing faster than that one did when it started. So I'm really excited about what's to come. Remember to smash that subscribe button down below. And next we'll get into chapter 11, which is real estate financing and is an extremely long chapter. I think I'm going to break the math section out into its own video just because there's so much to unpack in that one. This was another video on the North Carolina Real Estate Exam Prep, Chapter 10. I'll see you in a second.